In many medieval courts, a confession was considered the strongest possible evidence. If testimony and witness statements were not sufficient to establish certainty, judges in some regions could authorize interrogation under pressure in order to obtain that confession. What many people imagine as uncontrolled brutality carried out in secret chambers was, in numerous jurisdictions, part of a defined legal process tied directly to how justice was understood at the time. These practices were not completely arbitrary. Written procedures often determined when interrogation under pressure could begin, who had authority to supervise it, and under what conditions it was supposed to end. This does not mean the system was humane or fair by modern standards. However, it does show that the use of coercion existed within structured legal frameworks that believed confession represented the highest form of proof. Across parts of medieval Europe, particularly in systems influenced by Roman legal tradition, courts aimed for a level of certainty that could be difficult to achieve through physical evidence alone. Documentation was limited. Forensic methods did not exist. Witnesses could be unreliable or influenced by social pressure. Because of this, a voluntary confession was considered the most reliable confirmation of guilt. When that confession did not occur naturally, interrogation methods designed to apply pressure were sometimes authorized. Authorization typically required approval from a judge or magistrate. In theory, this approval was granted only when partial evidence already existed. The idea was that torture should confirm suspicion, not replace investigation entirely. Legal manuals in certain regions even outlined formal steps that had to be followed before permission was granted. There were also supposed limitations. In some areas, interrogation could only be applied once. In others, repeated sessions were allowed, but had to be recorded. Certain groups were officially exempt, including children, the elderly, or individuals considered physically incapable of enduring the process. Again, whether these restrictions were respected depended heavily on the authority overseeing the case. The methods themselves varied widely. Some focused primarily on psychological pressure or controlled discomfort. This could involve enforced positions that created fatigue or prolonged questioning designed to break resistance. Other techniques were mechanical. Devices such as the rack or the strappado were used in certain courts to apply physical strain intended to force admission of guilt. According to legal theory at the time, these techniques were not meant as punishment. They were considered investigative tools. Once a confession was given, interrogation was expected to stop. In many cases, the confession then had to be repeated voluntarily later, outside of interrogation conditions, in order to be formally accepted. Despite these procedural steps, the reliability of confessions obtained under pressure was often questionable. Historical records indicate that individuals sometimes admitted to crimes they had not committed simply to end the experience. This created situations where the pursuit of certainty actually produced false conclusions. Yet within the legal mindset of the period, confession still carried immense weight. The use of coercive interrogation was also shaped by broader social and political pressures. Periods of instability, fear, or perceived threat often increased the urgency to identify and punish wrongdoing quickly. Maintaining authority and public order was considered essential for survival of communities. In environments where distrust was high and evidence was scarce, systems designed to force clarity were more likely to be used. Religious influence also played a role in shaping attitudes toward confession. Admission of guilt was not only a legal requirement in some contexts, but also a moral and spiritual concept tied to ideas of repentance. This further reinforced the belief that extracting a confession was both necessary and justified. Over time, however, opposition to these practices began to grow. Legal scholars and philosophers increasingly questioned whether truth obtained through coercion could be trusted. They argued that pain or fear could produce statements disconnected from reality. As literacy increased and documentation improved, alternative methods of investigation became more effective. Gradually, reforms reduced the formal role of torture within many judicial systems. By the early modern period in several regions, laws began restricting or abolishing its use entirely. This shift marked a significant transition toward legal frameworks that prioritized evidence, testimony verification, and procedural safeguards. The transformation did not occur instantly. In some places, older practices persisted longer than in others. But the overall trajectory moved towards systems that relied less on forced confession and more on documented proof. Looking back at these practices reveals more than individual acts of cruelty. It illustrates how entire legal systems can evolve based on the assumptions they hold about truth, authority, and human behavior. What was once considered a legitimate investigative method eventually became widely recognized as unreliable and unjust. Understanding this historical evolution does not excuse what occurred. Instead, it provides context for how definitions of justice change over time. By examining the structure behind these practices, we gain insight into how societies attempt to balance order, authority, and fairness under very different conditions. Today, modern legal principles emphasize evidence, due process, and the presumption of innocence. These standards developed slowly, shaped in part by recognition of the failures inherent in earlier systems. Studying this transition helps explain why contemporary justice systems place such importance on voluntary testimony and verifiable proof. The story of medieval interrogation practices is therefore not only about harsh methods. It is also about how institutions learn, adapt, and redefine what constitutes reliable truth. If you found this deeper look into how historical legal systems actually functioned interesting, consider sharing your thoughts in the comments. And let us know which historical system you'd like explored next.